Hello, my name is Colton James, family name Waslin. I'm here today by special appearance solely to address discovery and clarify matters from the previous hearing. I am not submitting to the court's jurisdiction for any other purpose and preserving all objections related to jurisdiction. At my last appearance, I was under the impression that there would be no plea entered and the papers would reflect that, as well as me maintaining my innocence, including my constitutional right to assert my innocence. I want to reaffirm that I am maintaining my innocence.
If you want to make a statement on the record here, because we are on the record in court, you have to speak into the microphone so that it can capture your words.
Is this on the calendar? I guess I'm just confused as to what it is.
I want to get to that.
Where's the microphone?
It's sitting at council table right there.
Okay. Do you want me to sit or?
Yes.
Okay.
Let's start again. What is your name, sir?
My name's Colton James, family name of Waslin.
Waslin. Colton Waslin. Cause number 5A0561562 and cause number 5A0561563. Mr. Waslin, I see that we're here for a pretrial hearing. Let me hear from the city first.
I do not believe that Mr. Waslin has gotten an attorney yet, and don't know if he wants one. I believe he mentioned at the last hearing that he wished to proceed pro se, but that's not really something in the control of the city.
Okay. So first things first, Mr. Waslin, you need to be represented by legal counsel, or you need to represent yourself. Would you like to apply for a public defender, or would you like to hire an attorney of your own?
I wish to be here at present as myself.
I can see that you're here at present as yourself. What I'm asking you is whether you would like to be appointed a public defender, or whether you would like to hire an attorney of your own.
I wish to do neither.
Well, so, Mr. Waslin, you're not allowed to appear without counsel unless you are asking the court to approve that you be allowed to represent yourself in pro se.
I thought my
Buckle up, guys. Today we are diving into a courtroom compilation where confidence collides head-on with the reality of the legal system. Right from the opening, we're introduced to three individuals, each facing the court under completely different circumstances, but sharing one thing in common. They all believe they know the law better than everyone else. That alone sets the stage for a series of intense exchanges, unexpected arguments, and courtroom moments that only get more dramatic as the proceedings unfold.
Legal counsel, you may do that. I don't recommend it, but we can go through that procedure if that is what you are requesting.
Would I just be able to get a continuance then at that point? Because I need to brush up on a few things so that I may accurately defend myself.
I'd hear from the city if Mr. Waslin is making a motion to continue. He's not currently represented.
Your Honor, I don't have an objection to the continuance. I don't think we need to do a colloquy today. It doesn't sound like he's quite there where he's necessarily waiving. He's still making that decision. City doesn't have an objection. We would need a speedy trial waiver. I believe Speedy's running well, actually, let me check if it's running from today or if it's running from sorry.
So I see two cause numbers according to Jabs. Pleas of not guilty were entered on the 28th of August.
Which was a misrepresentation of what my intentions were, which is what I also wanted to talk with the court about.
Your Honor, the docket makes it very clear the defendant state he is innocent of the above charges. That's what was discussed last time we were here. He seems to be rejecting the terms used in this court, but he made an innocent plea on 8/25, and it does look like we would need a speedy trial waiver if there was going to be a continuance today.
I do see that in looking at the court's record, Mr. Wasland, it states that you stated that you were innocent of the charges, which is not the language that we customarily used, but if you are not pleading guilty, you are going to be pleading not guilty. There is no third option. That said, it was noted as entered back in August, not guilty pleas to both charges, which preserve your constitutional rights to trial and everything else. We will hear your request for a continuance today. If that's what you want, I'm prepared to grant it. Counsel for the city has reminded us that the speedy trial requirement, that is to say the time requirement for you to be brought to trial constitutionally under the state of Washington's laws, requires you to waive that speedy trial if you are asking for more time, because a continuance would take you out beyond that.
Okay, just out of clarification, so the Sixth Amendment does not give me the right to represent myself?
I am not your attorney, Mr. Wasland, and I am not attempting to give you legal advice.
But you are saying that I have to ask to represent myself when I believe that the Sixth Amendment right is the ability to represent myself as like a constitutional right. So I'm asking the court on why that it's not really being allowed.
All right, guys, here's where the first courtroom battle begins. Colton walks in claiming he's making only a special appearance and immediately distances himself from the court's jurisdiction while insisting on preserving all of his rights. Instead of answering straightforward questions, he carefully chooses every word, hoping to avoid legal consequences. The judge remains calm and methodical, but it's already clear this hearing won't be a routine one, as both sides prepare for a legal tug-of-war over procedure and authority.
I think that the court will be willing to do that if you indicate, in fact, that you do want to do that. I had heard that you were asking for a continuance in order to better prepare, which frankly is a good idea.
The continuance was only due to the fact of you saying that I wasn't able to represent myself or act, for myself, defending myself. If I am able to, then I would like to continue and we can go. But if not, then a continuance would be in order so that I can revisit a few things.
So to take the first issue first, Mr. Wasland, you are not constitutionally guaranteed the right to represent yourself in court. You are constitutionally guaranteed the right to have an attorney represent you. If you wish to represent yourself in court, the court may engage in what is known as a colloquy with you at a later time, that is to say, not today, in order to see if you are qualified to competently represent yourself. That's something that can take place at a later date. The court will hear your motion to be qualified as a pro se defendant. I also heard that you are asking the court to continue these cases so that you can have time, presumably, to prepare for that colloquy, if that's what you want. I'm prepared to grant it. I will tell you, though, that I cannot grant it if you do not wish to waive your speedy trial right, because your trial is currently set. Pardon me, it's not set, but we have speedy running when?
From the 28th of August.
That would take us sometime into next month.
Mm-hmm.
How much time are you asking for as a continuance, Mr. Wasland?
Well, honestly, I only came here by special appearance to assert innocence and request discovery, but given the matters that...
Your not guilty pleas have already been entered at your last court appearance.
which I didn't want to plea or contract with the state or city of Bellingham, which was the issue at hand. I just wanted to maintain my constitutional right of innocence is
your constitutional right to a trial and the presumption of your innocence, as well as your right to an attorney and all of the other rights that were discussed, are maintained.
I mean,
Now the conversation shifts into one of the most misunderstood legal issues, self-representation. Colton refuses both a public defender and a private attorney, believing he can simply appear on his own terms. The judge patiently explains that representing yourself isn't as simple as declaring it. There's a legal process that must be completed first. Instead of creating conflict, the judge relies on constitutional principles and Supreme Court precedent, turning this exchange into a lesson on how courtroom rights actually work.
State of Washington.
okay.
If you're asking for a continuance, you need to tell me whether you want to go to trial before November 28th or wish you'd rather to continue until after that date.
We can go before if you want.
I don't have any position in the matter, Mr. Waslin. You're appearing before this court.
I'm fine with that.
And
You're
Your
fine
Honor,
with what?
With
Perhaps-
going before.
perhaps what might make sense is if we just set it over without a speedy waiver, do a very short set until, until the presiding judge is back and can go through the colloquy, perhaps a week or two.
Certainly, I'll say that, Mr. Waslin. We can continue your matter inside of the time remaining for the speedy trial requirement.
Okay.
But it will be a very short amount of time to prepare for trial if that is what you wish to do without waiving speed.
That is fine, as long as I am able to pick up my discovery today at the end of court. That'd be totally fine with me. Because they have not done their obligation of submitting it to me by CR R 4.7.
So, Mr. Waslin, as I understand it, you do not have counsel appointed or having made a notice of appearance in this case.
I'm notice of a special appearance, yes.
And you have not.
Your Honor, the city will follow the rules for discovery for criminal procedure. Soon as we get a request for discovery, we will comply with it within the timeframes that we're required to.
Thank you, counsel.
Your Honor, what I understand the preference, but CR 4.7 allows I am preserving my rights while requesting discovery, and the continuance I'm obligated to have that, not necessarily by written. So this would be my formal request.
The city has indicated that they will follow the court rules regarding discovery, Mr.
Okay.
Waslin.
And can I pick it up today?
No.
No.
Okay, tomorrow? Monday.
Mr. Waslin, you'll address the court while you're sitting before the court.
Okay.
I'm trying to recall the rule of court that requires presence in person or virtual or via counsel. And I believe
3.4.
3.4.
it's 3-4, yes.
And just as clarification, this is the omnibus hearing, right?
No, it is not.
It's a pretrial?
That's correct.
Okay.
Mr. Waslin, we have a court appearance that we are setting in your two cases. As I said, you are to appear timely. You are to not violate the criminal law of the state of Washington. You are to update any address changes with the court and with Department of Licensing. You are to only use your true legal name and date of birth to identify yourself to the court, and you are not to drive without a valid license or proof of liability insurance. I have noted on this order that the defendant has requested a continuance. He has noted that he does not wish to waive speedy trial, and he has requested to represent himself in pro se. Arraignment having already been accomplished here, not guilty pleas entered and probable cause found. I don't think that there's anything further.
Your Honor, just promise to. He just needs to sign a promise to appear.
Okay. Mr. Waslin, the promise to appear is before you. When you sign it, we will have a copy made for you so that you can take it with you.
Okay.
Things become even more intense as Colton challenges the court over the not guilty plea and questions whether his constitutional rights are being respected. The judge carefully explains the difference between maintaining innocence and entering a legally recognized plea, while also outlining why self-representation requires judicial approval. Rather than losing patience, the court methodically answers every concern, showing that legal rights come with procedures that must be followed before those rights can be exercised in court.
The parties to this litigation are bound by the Washington Rules of Court, which govern production of discovery documents. Counsel for the city has indicated that they will follow those rules, and I have no doubt that they will.
Okay.
Your attorney, or you, if you represent yourself after you have been allowed by the court to represent yourself, can make a request for that discovery, and it will be responded to.
So I do understand the preference of making the request. However, it is up to them to be. It says the CR 4.7 says the prosecuting attorney shall disclose to the defendant.
Mr. Waslin, you're not an attorney.
No,
You
but I'm
don't
just
represent
asking you,
yourself
I'm
right
asking
now
you to
today.
have them.
You don't
you know.
represent yourself. You have not been allowed to represent yourself yet. You have the right to have an attorney represent you, and one can be appointed to you if you want, and you qualify. Now, if you want to request that the court allow you to represent yourself as your own attorney, that is a legal procedure known as a colloquy that you can engage in. I heard you ask for a continuance so that you could prepare for that, and I granted it. I cannot give you legal advice, sir. I can only tell you when your next court date is and what the order of the court is.
I'm not asking for any legal advice. I'm asking for them to at least be obligated to give it to me without the referral request or the written request.
Your Honor, it requires a written request. 4.7 requires a written request. If we get one, which can be as simple as emailing, you can email me, which is megood@cob.org, and I will make sure that request, that discovery gets to you.
So I have to ask you for your obligated
Mr. Waslin,
obligation.
address the court when you're sitting before the court.
So I have to ask them, like,
All right, guys, this is where the discussion reaches another critical turning point. Colton continues insisting that his constitutional rights are being misunderstood, while the judge repeatedly explains that no rights are being taken away. Only the proper legal process must be followed. As the exchange continues, the court agrees to grant a continuance, giving him time to prepare for a future hearing. It's a perfect example of patience meeting persistence, with neither side willing to back down from its position.
Then do we have Mr. Mula here? Excellent. This is case number 25M1510. I understand, Mr. Sullivan, that your office might have a conflict with this case?
Yes, Judge, and I believe it was filed with the court.
Okay. So let me unmute Mr. Mula. So good afternoon, Mr. Mula. This is Mr. Sullivan. He's here with the Office of the Public Defender.
Yes.
They have a conflict with your case, so if you remain in custody, I'm going to appoint a lawyer to represent you.
I represent myself, ma'am.
Okay.
It's a right. So
Yeah, sure.
I represent myself. Yeah.
Thank you. I don't need you to advise me of the law, sir. But if you'd like to exercise your Sixth Amendment right to represent yourself, you may. Let me hear the people's bond argument, and then if you'd like to make an argument, you may. I'm going to mute you while they do that. Thank you. Ms. Mayfield, what is your argument regarding bond?
Your Honor, I don't think I have an argument under 164113.
So I'm not sure if you do you know what happened yesterday?
Maybe not.
So yesterday, Mr. Mula appeared in Division 7 and was extraordinarily disruptive, using very foul and offensive language, very obstructionist behavior in the courtroom, failing to adhere to court orders, to appear at the lectern, essentially failing to adequately identify himself. What I'm going to do is allow you to make any argument you'd like to make, Mr. Mula, and then I'll make a ruling regarding bond.
Yes, ma'am.
Thank
I was
you.
illegally detained on a bench warrant that was issued while I was in a courtroom for a non-appearance. So yes, I got irritated. I know my rights, ma'am, and I have the right to travel in regards to the first trespass charge. So also, I work with the homeless community here.
Okay.
I work with all the programs.
Okay, if you could wait just a sec, what I'm going to do is ask you questions under the statute. I'm going to ask you questions under each subsection. Don't talk about the allegations, okay? So, what is your
Now the focus shifts from self-representation to discovery, and that's where another legal disagreement unfolds. Colton argues that the prosecution should immediately provide evidence, believing the rules require it without delay. The prosecutor and judge calmly explain that discovery follows a specific procedure and must be requested according to court rules. Even though Colton keeps pressing the issue, the court stays focused on process, showing that legal obligations are fulfilled through established procedures rather than personal interpretation.
sign that bond?
Yes, ma'am.
Okay. Let's see. What are your ties to the jurisdiction?
To the jurisdiction.
To Boulder? Boulder
I've been
County?
here for 2 years, seeking sanctuary, and I've been bullied and targeted and harassed by cops and other organizations since I've been here for helping the homeless.
Okay, and just wait. Ms. Mayfield, you said you don't know of any record you can make under E or F. I do not. Okay. All right, Mr. Mula, was there anything else that you wish for me to know before I address your bond?
Nope.
All right. Okay. What the court is going to do is authorize a $1,000 co-signed personal recognizance bond, no contact with the victim, pretrial supervision.
And who is the victim?
Let me take a look.
And what are the charges? I didn't hear any charges. So
Yep. So let me tell you, you were, I think, issued a summons, but let me take a look. Yes, you were. And so when you were issued the summons, the
I don't have
charge.
an address.
Just a sec.
I live in a car.
Somebody likely handed it to you, but let me take a look. And how about we do this? I don't interrupt you and you don't interrupt me.
Sure.
All right.
Thank you.
You're welcome. Yep, it looks like the officer tried to hand you the summons, but you refused it. So let me share with you what the charges are. You're charged with the unclassified petty offense of third-degree trespass and the Class 2 misdemeanor of obstructing a peace officer. As it relates to the address you are alleged to have trespassed,
Kevin G. Fine.
well, do you see that, Ms. Mayfield? That it's Evan G. Fine? Oh, here, oh, yep, it is. So when I say no contact with the victim, it's Evan G. Fine.
Okay.
Okay? You asked me what that was. So now, let me tell you,
Can I ask a question when you're done, ma'am?
you may ask that question right now if you would like.
How is a public space a victim?
So you are trespassed from that area, and so what I'm saying to you is no contact with Evan G. Fine Park.
Well, the officer that I had initially interacted with said that it was only during the hours of.
This final segment of Colton's hearing wraps up with the judge laying out the conditions that will govern the case moving forward. From signing the promise to appear to explaining why discovery cannot bypass court rules, every question receives a measured response. Colton continues challenging the process, but the judge repeatedly reminds him that representing himself requires formal approval first. It's a calm but firm ending that highlights how courtroom procedure consistently outweighs personal legal theories.
Formal charge that's been filed. And Mr. Slocum, do you have a copy of that complaint information?
And I'm sorry, was this Mr. Gavin?
Yes.
Okay.
And so this is a copy of the complaint information. So hang on to that. It has some limited information about the charge that was filed and your case number. Mr. Gavin, are you planning on applying for the public defender's office?
No, ma'am.
Okay, you're planning on hiring a private attorney?
No, ma'am.
Okay, you're just going to represent yourself?
Yes, ma'am.
Okay.
Okay.
All right. Well, Mr. Gavin, do you have any legal training?
No,
Okay. Have you ever filed a motion for, okay, have you ever had a motions hearing?
I'm not illiterate, Your Honor.
I'm certainly not implying you're
That's
illiterate.
what I feel. So can we please
Okay.
approach?
No. So my concern is that you want to represent yourself, and it's not that I'm implying you're not intelligent. What I'm trying to just advise you of is that the legal system is really hard to navigate and it's very complicated.
Your Honor, I understand, but that has nothing to do with me, Your Honor.
Buckle up, guys, because the second courtroom story begins with an entirely different personality, but a familiar approach. John Mula immediately rejects appointed counsel and confidently announces that he will represent himself. Before any arguments even begin, the judge explains the situation involving a conflict with the public defender's office and gives him the opportunity to speak later. From the very first moments, it's obvious this hearing is headed toward another tense exchange between personal beliefs and courtroom procedure.
All right, I'm going to give you an advisement here. It's called an Arguello advisement, and it's required for individuals that want to go forward pro se and represent themselves. I want you to know that you have the right to counsel. You can hire a private attorney, apply for the public defender services and see if you qualify, and then one would be appointed at no cost to you. Do you understand that you have the right to be represented in this proceeding?
Your Honor, is there a bond on this?
Sir, if we can't get through an Arguello advisement, then I can't continue your case. So we're either going to get through this advisement or I'm just going to keep setting you over until we do. So what would you like to do? Go through the advisement so that you can then represent yourself and your case can move forward?
Your Honor, is there a bond on this case?
You're out of custody, so you've posted a bond if there was one.
Is there a social security on this case?
I don't know what that means. A social security what?
My social security number.
It's, yes, your social security number is associated with you in this case.
Right, so it's tied to all my charges, correct?
Your social security number?
Yes.
If it's associated with you and you're associated with this case, then I would assume it's a part of.
So I am the benefit.
All right, guys. The tension rises quickly as the court turns its attention to John Mula's behavior and the reasons behind his arrest. While the prosecutor describes his disruptive conduct inside the courtroom, Mula insists he was illegally detained and repeatedly points to his constitutional rights. Even when the judge asks simple questions about his background, his unusual responses keep the hearing from moving smoothly. It's another reminder that courtroom proceedings depend on cooperation just as much as legal arguments.
There was a failure to comply warrant that was issued on September 5th. And there's a no bond hold. So you're gonna be remanded and go into custody on that case. And what we could,
September 5th, I was in custody.
that's when the warrant was issued.
I was
For-
in custody, ma'am.
That very well may be. So the warrant was issued on September 5th, advising that you failed to comply in 21 CR 5803. Having an attorney would certainly help you understand everything that's going on. Either way, you're going to be remanded on that case. And then this case is going to,
The bailiff can't touch me. That's illegal for the bailiff to touch me. You're a servant. You're a deputy sheriff, either or. You're not allowed to touch me.
That's not how this works.
How is there a warrant? How is there a warrant for someone in custody?
so I think what I'm going to do with this case, I haven't gotten through an Arguello advisement, but I tried and it doesn't seem like we're going to get there. So I'm just going to send it to Division 8. We'll set it for an arraignment there. We'll make a note that Mr. Gavin is wanting to represent himself and that he still needs an Arguello advisement, and Judge Bentley can work on that. And then Mr. Gavin will be remanded on 21 CR 5803 in that court.
I'm not going to be remanded for something I didn't do. I was already in custody.
It doesn't matter.
It does matter. How do I get another charge if I'm bound?
If you were
I
willing to
bonded.
listen, I could explain this
I
to you, but
bonded
you're
out,
not,
Your
so
Honor.
I can't explain
Your
it
Honor,
to
I
you
bonded out.
on this case.
Yes, there was
I'm
no other
talking about in
case.
a different case.
How do I have another case if I'm already in jail?
It's 21 CR 5803.
25, excuse me?
21 CR 5803. 803.
And what is this under?
This is a.
What are the charges?
Probation case. So that's the case.
Now the hearing reaches its most important moment as the judge rules on bond and begins explaining exactly what charges Mullah is facing. Instead of quietly listening, he repeatedly interrupts, forcing the judge to regain control of the courtroom before continuing. Once order is restored, the allegations of trespassing and obstructing a peace officer are finally laid out in detail. It's a perfect example of how courtroom discipline often determines whether important information is heard or delayed by unnecessary interruptions.
I was already in custody.
I understand that on this case, and you
I
bonded out on
bailed-
this case.
I bonded out.
And then there was a warrant issued on your.
How was there a warrant?
Because there was a failure to comply based on this new case. When you're on probation, it's a violation of your probation to get charged with new cases.
Okay, so what is this
Great.
number again, please?
Mr. Gavin.
Can I get this case number?
She said you got it.
I'm trying to get right down this case number.
Sorry, I've given it to you multiple times. I can't help that you're not listening to me.
I'm just trying to put this, man.
Yeah, I'll grab that.
Damn it, every time I come up here, y'all trying to put me in here, man. I'm tired of you, Honor, too. You're just a servant here.
Don't resist, man.
I'm not resisting.
You are resisting.
Man, you trying to hit me on a pin cap,
Don't
dog.
resist. Put your hands behind your back.
I have my hands behind my back. You guys are over
Right
and
there.
react. Definitely. Because I can slam all y'all.
Stop resisting.
I'm not resisting.
You are.
How am I resisting, Martinez?
I don't know who Martinez is, but it's not me.
Well, don't know. How am I resisting? Just bonded out. So y'all try to play the game and bond out to take people's money, right?
You're on the cricket phone, so. All right. All right.
These are my things. Still
Yeah,
have my-
we'll grab your things.
I have my information, correct?
As this courtroom session comes to a close, the judge finishes explaining the charges and the legal process that lies ahead, making it clear that the case is only just beginning. Throughout these hearings, we've seen how confidence, personal beliefs, and constitutional arguments are all tested against established courtroom procedures. No matter how strongly someone believes they're right, every claim must still fit within the rules that govern the justice system. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and turn on notifications so you never miss another case. Thanks for watching, and we'll see you in the next video.